Welcome to this week's installment of Rochelle's Daily Wire, video edition. As you can see, the weather is glorious here in the desert Southwest. Back at ABI's headquarters in Washington, D.C., I understand, however, that the weather is stormy. However, we're not here to talk about the weather. We're here to talk about important developments in bankruptcy law. This week, we go to the Second Circuit in a significant decision dealing with arbitration in the bankruptcy context. That decision on March the 7th is in a case called In re Anderson. But first, some background. With regard to arbitration of bankruptcy remedies, the issue in the Second Circuit seemed to have been put to rest back in the year 2006 in a Second Circuit decision called MBNA versus Hill. In that case, the debtor mounted a class action against a creditor for having violated, allegedly, the automatic stay in bankruptcy. When the case got to the Second Circuit upheld an arbitration clause and, in essence, knocked out the class action. Well, pretty much the same thing happened in this new case on March the 7th. There was one slight difference, however. Instead of alleging a violation of the automatic stay in a class action, the debtor alleged that the creditor had violated the discharge injunction. Now, you would assume that the result would be the same and the Second Circuit would uphold an arbitration agreement, but that's not what happened. Instead, the Second Circuit allowed the class action suit in district court to go ahead. Actually, it wasn't in district court. The class action was in bankruptcy court, indeed, in a bankruptcy court presided over by bankruptcy judge Drain in White Plains, New York. Well, in any event, I have difficulty reconciling these two decisions. I'm not sure how much is left of the 2006 decision called Hill. In any event, you can make up your own mind. I very much recommend reading the opinion in full text. You can get it from the Second Circuit's website. Or better yet, go to ABI's website, find my column, and find my discussion of the Anderson decision. At the bottom of the column, you have a link to the decision. Until the same time next week, this is Bill Rochelle saying, be well, don't work too hard, and enjoy life.